Hi, it's Mark Gracie here. Thank you for joining this webinar. We're going to be looking at the GDPR, the General Data Protection Regulation, and I'll be talking about the basic changes that it introduces to the data protection regime of the UK. Hopefully you can see the slides. You should see a title slide with the title on it and a sort of a background photo. If you have any questions, we'll take questions at the end. There's a questions panel in your control panel for the webinar, and you can type your questions in there and we'll pick them up at the end. I'm recording the webinar, and I'll distribute that afterwards, so you'll get to see a recording. So in case you need to revisit anything on that. Okay, so first, just a little bit about myself. My name is Mark Gracie. I run a company called Flavify Digital, and I help businesses with their digital compliance. At the moment, for obvious reasons, a lot of that is involved in dealing with data protection compliance because of the GDPR. And I run a service called the Digital Compliance Hub, which is a online service, a mix of help, support and guidance, and a helpline. So if you need help, toolkits, guidance, want to be able to speak to somebody when you need some help, then the Digital Compliance Hub is an excellent resource for that, and I'll talk a bit more about that a bit later on. But just to give you some background, I've worked in the internet industry since the mid-90s. An element of that was being a data protection officer for some internet companies around the time that the Data Protection Act came into force in 1998. So I totally get data protection compliance and what it means to introduce that within a business, and a very certainly internet and telecoms businesses have lots of data, as I'm sure you can imagine. So I understand the complexities of that compliance. I had a 15-year career as a regulatory manager, which was part internal compliance with various regulations, primarily around internet, but also data protection, as I mentioned. And the other aspect of it was external stakeholders. So I've worked with the government and various other parties to empower everybody to have an appropriate compliance regime in place, mainly for the internet industry, as I say. And there was there's always been lots of discussions about data, particularly in internet environments, not just from a data protection point of view, but from data retention, access to the data by law enforcement, and so on. So that's by way of giving you a brief overview of what my background is, so as to why I'm talking to you about data protection. So let's move along and actually start talking about the GDPR. So hopefully by the end of this webinar, I don't know if I said, but I'll probably be talking about 30-40 minutes, and then there'll be time for questions. But at the end of the webinar, you should hopefully have an understanding about what the GDPR is all about, some thoughts in your own mind as to whether you need to worry about it for your business, and if you do, some hints and tips as to what you need to do to sort of get yourself on the road to compliance. Before we actually start talking about the GDPR, I just want to go through a few things relating to the basic underlying principles of data protection, because I might use words and terminologies that make reference to data protection in general. So it's worth just going through those so that everybody's on the same page in terms of what data protection is really all about. So let's start with some definitions. There is a number of definitions in data protection. GDPR's got probably 20, 25 or so on the regulation, but on the screen now, those slides sort of represent 5 key definitions. It's always worth just clarifying what they mean. So data protection is about the protection of personal data. Personal data is data that relates to well, is actually any data that enables you to identify a living individual. The data itself might not be personal data except when it is put with other data which enables you to identify the living individual, which would then make that data personal data as well. But if you can identify a person from the data, then that's what personal data is, and data protection applies. Now, in a business-to-business environment, it's slightly confusing because to start with, the Information Commissioner, our regulator in the UK, and the enforcer of data protection, says that sole traders in a business environment are actually individuals and not businesses, and therefore if you deal with sole traders, any of their data should be treated strictly as personal data. And actually, even business people within their businesses, so an employee within a sales team or a person that you're targeting within a particular business for, say, your marketing, their data, if you can identify them even as an employee, their data is also personal data, and data protection applies. There's some other rules around what you can do in a B2B environment relating to marketing, and I might touch on those when I start talking about consent and what that means, but there's some other areas of consideration, and certainly look out for some other webinars in that particular area. But just to be clear, if the data you have identifies a person rather than a generic corporate identity, then data protection applies. Now, when we talk about data protection processing and actually using the data, processing actually covers every aspect of that data. So it's not just the use of it, it's storing it, it's the collecting of it, it's the transferring it, it's the changing it, it's the manipulating it, it's everything relating to that data. So don't just think about processing as in what you're using it for, but also it's about storage as much as everything else. And that's quite an important thing to bear in mind. A data subject is the person whose data it is that you're using or has been collected. The data controller is the organization that's collected the data subject's personal data and is determining how that data is going to be used. The data processor is a party who is being typically instructed by the data controller to process data on their behalf. So you essentially have a sort of a triangle of people involved in this. You have the data subject, who's the individual's data it is, the data controller, who's determining how that data is going to be processed, and the data processor, who may be used by a data controller to actually do the processing. And typically there'll be a third party. So for example, if you're a data controller and you pass your data to a marketing agency to deliver your marketing messages, they will be the data processor, you will be the data controller. And it's worth just making sure you understand those definitions. Obviously, as a controller, you may be processing the data, but you'll still be the controller. But if you're using third parties, then a processor will be involved in that. And that's important because there are some changes in that which we'll get onto in a moment. Now, underpinning data protection are the principles. The Data Protection Act talks about 8, which are kind of reflected on this slide here. The GDPR talks about 6 typically, which are the top 6 in that on that slide. But it also talks about some others about accountability and things, which we'll get onto in a bit. But in a general sense, these are the principles of data protection. In GDPR terms, individuals' rights and international transfers are still in the regulation. So there's no change there. It's just they're not defined as particular principles. So let's just quickly run through those. If you're processing data, then you need to do so lawfully, fairly, and transparently. So you've got to be open about what you're doing and why you're collecting the data and how you're going to use it. You must only process it for a specific purpose, so you need to define what that purpose is and not process it for other purposes unless there's a lawful reason for you to do so, or you've got consent from the data subject to use it for those other purposes. The data you collect and you process has to be relevant, so don't ask for data that you don't really need. You have to keep it up to date and accurate. You can't retain it any longer than you have a business need to do so. So once you've finished doing the processing, if there's no business or lawful reason for you to keep or process the data, then you must get rid of it. And security, you have to keep that data, and your processing of that data has to be done in a secure manner so that there's no opportunity for a breach or an unlawful access or an unlawful processing of it by a third party who's unauthorized. And then the other two at the bottom, individuals' rights. These are the rights that the data subject has relating to the controller's use of their data. Probably the most well-known individual's rights is the data subject access request, which is a request to ask the data controller, what data do you hold on me, how do you process it, and request a copy. but there's some new ones coming in which we'll touch on. And then international transfer is that you're not allowed to process data outside the EU or transfer data outside the EU unless certain criteria are met, and they're typically that you're passing them to an organisation in a country that has an adequate data protection regime in place, and there's a list of adequate countries on the European EU's website, and if it is a country that doesn't have an adequate data protection regime, for example, the United States don't, then there may be a mechanism in place which in the US used to be called the safe harbor. They've now got a new system in place. Then you must only operate or share information with those parties who are signed up to that procedure, or in other circumstances that you have very binding controls in place in a legal perspective relating to the individuals who are processing your data, and that they will only process it within a strict EU compliant way. So those 8 things there are essentially the underpinning principles of data protection. And then you have the lawfulness of processing, which is all about under what circumstances can you lawfully process the data that you've collected as a data controller, or even as a data processor, based on the data subject. So the obvious one is the data subject says it's okay, they've given you consent to process. You can also process data if it's required for the delivery of a service, or as the law refers to it, as a performance of a contract. So you don't need to ask consent to say, I need to collect this data to be able to deliver the service. You don't need to ask consent to then actually use the data. It's implicit in the fact that you need that data to perform that service or deliver the product. You might be obliged by law to process the data outside the requirements of your original purpose. A good example there is we will have to keep tax records for up to 7 years, so that's a legal obligation to require you to keep certain data and therefore process data outside the other aspects of when it may be lawful to process. You may be obliged by law or maybe by a regulator to store data for other purposes or process it in other ways. So, for example, law enforcement have access to pieces of legislation which enable you to process the data and disclose it to them under certain circumstances. The next 2 are about interest. So if it's in the interest of the data subject that you process the data, then that may be your lawfulness for processing. I guess in that kind of scenario, that would be something like a doctor disclosing information to, say, the police for the purposes of telling them that they're a bit worried that somebody might come to harm or the data subject might be harmed. So they wouldn't ask consent of the data subject to share it with the police in that scenario. And it's not really part of performing a contract, so it would be in the interest of the data subject that maybe that data was disclosed for those purposes. And then I guess really for public bodies, if processing data is in the public interest, then that may be a basis for processing. And then there's a slightly sort of woolly concept called legitimate interests. If it's in your interest as a data controller to process the data, and it's done so that in a way that doesn't cause any significant harm to the data subject or harmful to the data subject, then you might have a legitimate interest in processing it. So a good example is that if you need to collect an outstanding debt from a customer, somebody's not paid you, then it's in your interests to be able to pass that data to, say, a debt collection agency for the purposes of collecting the debt, and you would claim that you have a legitimate interest in processing the data in that way. You wouldn't have to ask consent, and sort of between that and being required for part of a contract, then you would be able to have a lawful basis for processing. So we've essentially covered the principles of how you can use data and how you can process it, and then there's the concept of what's lawful and what isn't. So let's get on to the GDPR. So what I'm going to talk about are 10 key changes that are coming with the GDPR. So this kind of presupposes that you have an understanding of data protection, but hopefully the sort of the introduction I've just done will help you in that regard. And I'm going to run through all of these. So that fan slide there represents the 10 key areas that I'm going to go through. So let's get going with scope. Key things to consider here in terms of the reach of the regulation. The key word is a regulation. So in European law terms, you may have a directive or you may have a regulation. A directive is implemented in member states according to member state law, where a regulation is implemented across the whole of Europe, regardless of how member states have implemented it. So it sort of gazumps any national laws that have any bearing on what the GDPR covers. So, for example, we have a Data Protection Act 1998. This was implemented based on a 1995 directive. The regulation, the General Data Protection Regulation, because it's a regulation and it applies across the whole of Europe, to all member states, will replace the Data Protection Act 1998. The problem with having a directive is that different member states implement things in slightly different ways, and that's one of the aspects of why we've got a new regulation, is that if you're an EU citizen, your data might be processed or managed or controlled, or your rights might be influenced depending on which member state you're in, and then that may change if your data is passed to a different member state. So the concept of having the regulation put in place to apply across all member states is that this is about making sure that there's a level playing field no matter where you are in Europe as a European citizen. Now, in terms of the UK, we're obviously planning on leaving Europe. If and when that ever happens, supposedly in 2019, there is this concept that we'll be leaving Europe, and that might have some ramifications for us. So I'll sort of touch on that a bit later. But the key thing is, regardless of the fact that we're going to be leaving Europe, this is a European regulation that comes in next year and will therefore apply to the UK. Furthermore, there's a data protection bill that's going through Parliament at the moment that empowers the legislators to implement GDPR within UK law anyway. So for all intents and purposes, whether we're leaving Europe or not, GDPR is here. So if anybody's telling you or you're hearing that it doesn't apply because we're leaving Europe, that's a load of rubbish. You've got no choice. GDPR is here, and certainly for the short term, probably for the long term, to be honest, GDPR is going to be with us in UK law, whether we're a part of Europe or not. The other thing is it has extraterritorial scope, which means that it reaches, it applies to businesses that are outside the EU that are processing data, perhaps because they're delivering services or goods to EU citizens, and there's some controls around how you would determine whether that person is delivering services to EU citizens, and there's some requirements about what those organisations would need to do. So there's no escaping the GDPR, even if you're not in Europe and you're selling services or products to European citizens. And just from a definitional point of view, most people kind of understand this concept anyway, but there's a reference to online identifiers now being included in the definition of what's a personal data. So, you know, typically people talk about bank details, name, address, telephone, email address, those kind of things. But there's also online identifiers. So if you have an online forum when people are identified by an online identifier, then that's going to be considered personal data as well. And just other thing, while we're talking about definitions, under Data Protection Act, we used to talk about sensitive data as sort of things that like medical and health records. GDPR refers to them as special categories of data, and there's specific controls around certain types of data that would be considered special categories. So medical and health, for example, biometric data, data relating to ethnicity, religion, race, sexual orientation, and those kind of things are all covered in a slightly stricter way than general, for want of a better word, personal data. So that's the scope. So covering much wider services and reach across the world. One of the data protection principles which is introduced and is key to GDPR is accountability. It's about the data controller, and in some instances the processor, being able to demonstrate that they're being compliant. So all pressure is on the controller and the processor to be able to confirm that they are processing data lawfully. what that means is that certain types of businesses and in certain areas of the law, and consent is one of them that we'll talk about in a moment, there is a requirement to record your processing activities and having records in place. If there's one thing I advise any business is that if you're able to document your approach to data protection and maybe consider how you can document your processing and how you use data, you'll be in a great place anyway, regardless of whether the regulation requires you to do it. So the regulation doesn't require recording processing activities for everybody, only certain types of businesses. But generally speaking, I think it's good advice that everybody should consider how they could record their processing activities, or at least have the ability to be able to demonstrate their compliance from that angle. So yeah, so think about your business and your whether you're a controller or a processor, and think about how you can be held accountable for your processing and how you can demonstrate that compliance. Now, if you run what's called an information society service, which is essentially a service running online, and it's likely to be accessed by children or is aimed at children, then there's a new set of rules actually on the face of the law relating to the collection of consent for processing of data relating to children. Now, a child's defined as under 16 in the regulation, but one of the things that the regulation does allow flexibility with is that member states can define that as younger if they wish, as long as they don't go below 13. Now, it looks as though at the moment, although it's being argued that this isn't appropriate, in the UK, 13 is probably the age of a child. So if you're running an online service that a child is likely to use, which means you might need to use age verification to validate actually whether they are a child or not, then you need to have child-friendly messaging. It's all part of the right to be informed. I'll talk about what that means in a minute. But a child needs to be able to understand what it is that they're consenting to. Probably having child-friendly messaging is not bad for adults either, but there's a specific requirement about being informed, and obviously if you're aiming your service at a child, then a child needs to understand how they're being informed. And there's also a requirement that if the person is a child, you need to get guardian consent as well. Now, on the subject of consent, this is the sort of the key area that marketing people are getting a bit worried about. There are new consent rules. If you are processing data where consent is the lawful basis for processing, so in a marketing sense, you've got you're collecting data to add people to your mailing list, or you're asking people to sign up to things in a sort of a cold prospecting marketing kind of way, then consent is applicable. And the key changes here are the first two bullets on the right hand side. Your messaging has to be clear and very transparent, and explain very clearly what the purpose is for collecting the consent and the data that you're going to be processing, and what you're going to do with that data. And you need to ensure that the data subject is taking a positive action to give you that consent. Now, what that means in real terms, and this is actually referenced in the regulation, is that you'll no longer be able to use pre-ticked boxes or tricky wording which can be missed by the data subjects that leads them into signing up when they sort of have to untick a box, or a double asterisk which takes you to some very small print that says, oh, by the way, we'll mark it to you unless you tick this box. That kind of wording is gone. You're not allowed to do that anymore. It has to be very clear how they are giving and delivering their consent for you to process the data for the purpose for which you're collecting it. So if consent is your lawful basis for processing, you need clear messaging, and you need a positive affirmative action by the data subject to ensure that they are delivering that consent. Just skipping those next few, right to the bottom, you also need to record when that consent is given. So this is one of the accountability principle aspects. You will need to be able to demonstrate that this person signed up or consented at this particular time. So you need to keep a record of that. And interestingly, if you're a MailChimp user, you may have seen that they last week they emailed everybody and said we're removing double opt-in to MailChimp mailing lists and making it single. And then this week they emailed to say, unless you're in the EU, in which case we're giving you double opt-in back. And that's because a lot of EU businesses said double opt-in provides some of the guarantees to meet the requirements of consent. for GDPR, and so they've said, well, if you're in the EU, you can have double opt-in back as default. So what double opt-in means is that you sign up on a mailing list form, maybe on a website. You then get an email saying you need to confirm your subscription. So there's a you can claim that that's your positive action by the data subject, that if they went down the route of filling in a form and ticking a box or clicking submit, they then will have had to have confirmed via email that they wish to subscribe, and that's your positive opt-in. Plus also, of course, MailChimp has the function to tell you when they signed in and everything, so that's the recording taken care of as well. So just a quick MailChimp tip there. Other things to consider with consent: you have to be clear if you're going to be sharing your data with any third parties. You have to be clear about how to withdraw consent, and if somebody does opt out after they've given you consent, they have that right, and you must make sure you honour that. So you can't carry on emailing them, you can't try and get them to come back and those kind of things. That's a pure opt-out, and you need to pay attention to that. And you also can't force people to give you consent for a particular reason. So you can't say, well, to be able to do this, you're consenting to me marketing to you, and that's just not allowed anymore. Key messages, therefore, for consent. I know this is an important area that lots of people are worrying about. Clear messaging, an affirmative, positive action by the data subject to give you that consent, and make sure you record the consent that's being given. So moving along, individuals' rights. I talked about the subject access required as being the well-known one. There's quite a few individuals' rights. They have rights to have their data rectified and various other aspects. I've highlighted here some key changes. So right to be informed. Everybody's always had a right to know what you're collecting the data for and why you're processing it, but the GDPR introduces some specific terms. So there's actually a list of things that you need to do at the point of collection of data to make sure the individual understands information about you, what you're going to use the data for, how they can complain, and so on. And that is slightly different if you're being supplied with the data by a third party, but you still need to provide information at some point. I've mentioned subject access requests. That's not a new concept, but what is new is that you can no longer charge a fee and you have less time. It has to be done within a month rather than the 40 days, and you can't charge the £10. There are some fee structures allowed, but they have to meet certain requirements, like the request is too onerous or too repetitive. But baseline is, if somebody asks you for what data you're holding on them, how you're processing, what you do with it, and ask you for a copy of it, then you need to be able to provide that free of charge within 30 days. Then the two new ones, which people are talking about quite a bit, is the right to be forgotten or the right to erasure. So a data subject has the right to ask you to not process their data anymore and to delete it. They obviously can't ask you to process data for the purposes so that they don't get billed. So you can't tell you to delete your billing information just to try and get out of being billed. That's not what this is about. This is about people who have data being processed that they no longer need, the data controller no longer needs that data, or it's found that that data is being processed unlawfully. The individual or the data subject has the right to request the deletion of that data. There's also a right to data portability, and what this means is that if the data subject has provided you with the data, then and you put it into a digital system, then you have the data subject has the right to request a machine readable export of that data so that it can be imported into another system. The kind of scenario where this is going to be used is if a customer is with one particular provider, say an electricity provider, and they want to switch providers, they will have the right to be able to ask their current energy provider to export their data in a way that can be imported into the new energy provider. And I've certainly been talking to clients who have various other approaches with how different systems might need to have that kind of interaction, because it's not some of the, that's what I'm trying to say, is it's not some of the very obvious consumer type scenarios that enable people to switch services easily. I think there's quite a wide ramifications here for a lot of businesses. So if you have a digital service, or if your data is stored in a system that you have have to consider whether you need to provide the right for data portability. Of course, at one end of the scale, you can say, well, the answer is let's export everything and import everything in CSV format. But actually, the regulation talks about maybe there are standards, maybe across industry or agreed standards put in place between system providers to implement this functionality. So sort of an update on a couple of rights, and then the right to erasure and the right to data portability are two new individuals' rights that data subjects have that they wouldn't have had before. Now, a significant change, particularly if you're a data processor, but also if you're using data processors and you're a data controller, then there's some things that are really changing in this area. So the key thing is that under Data Protection Act 1998, so under the directive of the EU directive, essentially with regards to with some exceptions relating to security, all responsibility lied with the data controller. So if they used a data processor who misused the data, or there was some problem that led to a breach of the regulation or the law, then it was the data controller's fault, and very rarely not the processors. That's all changing. So processors have responsibilities under the regulation. There's certain things that they need to do. But one of the key things that's changing is that the controller-processor relationship has to be managed from a contractual point of view. So there are contractual terms that are specified in the regulation that set out that if you're a controller working with a processor, you need to have those contractual terms in place. Now, if you're a processor, that means you need to work out how you're going to implement those contractual terms. You're going to enter into a legal discussion between your lawyers and your client's lawyers every time that a new customer comes on board, or an existing customer comes on board with a new contract, or are you going to implement it something perhaps within your terms and conditions. But regardless of how you go about it, you're going to have to look at these new contractual terms that need to be between the controller and the processor, and how you do that will depend on whether you're the controller or the processor. So what I'm seeing is actually a lot of customers of processors saying to them, what's your position on GDPR, and can you sign this new contract? So you might want to look out for that depending on where you fit in that model. If you're a controller, you might need to look at your third parties that you're using who are processing your data to consider what they are doing for GDPR, because one of the other things to consider is that you shouldn't be using a processor that isn't GDPR compliant and doesn't facilitate your GDPR compliance. So this is a big thing if you're providing, say, software as a service, or you're processing data as say a outsourced marketer, because you're a data processor. Not only have you got new responsibilities and legal liabilities under the regulation, which you won't have had before, but also your customers are likely to be asking you questions about GDPR, because they need to be sure that you can make sure that they're GDPR compliant, and they will want you to sign new contractual terms, or you need to implement new contractual terms within your terms and conditions. So there's a big shift here, which is impacting a lot more businesses than people realize. So if you're using a third-party CRM, for example, as a data controller, you need to carry out due diligence on that third-party CRM to make sure that they're GDPR compliant, you're GDPR compliant, and look out for the contractual changes as well. So big change for data processors, but there's also the controller relationship with those processors as well to think about. Now, data protection by design and default is a concept which is really new to the UK, because the Information Commission has sort of talked about privacy by design and default, but it's on the face of the regulation this time, and it's essentially a concept that makes sure that the data subject rights and the privacy of the data subjects are considered by default in anything that you do. Now, if you're implementing a new technological system, you should make sure that by default the rights and the data protection of any information that's going to be processed in that new system is taken care of. And there's a tool called a data protection impact assessment, which is essentially a way of carrying out that assessment. Now, that might be that you need to, in your project team, now include your data protection person to make sure that they can ensure that you're going to be compliant going forward. The idea here is that you're taking on board data protection at the beginning of a process rather than worrying about it afterwards. So that's data protection by design and default. Which all brings us on to data protection officer. So I talked about data protection person just a minute ago. Businesses might have a concept of the single point of contact within their business or the person responsible for data protection. The regulation takes that one step further and says that certain types of certain types of businesses have a duty to have a mandated data protection officer. So this is an individual who is notified to the Information Commissioner as the data protection officer for your business, and an individual who has a certain set of responsibilities that they must carry out, and the regulation basically tells businesses who need a data protection officer the terms by which that person should be allowed to work and get on and do their job. In a kind of oversimplifying it kind of way, it's to prevent businesses telling the data protection officer to go and sit quietly in a corner and not bother them about that annoying data protection compliance. It's actually to enforce the fact that they need to pay attention to what the data protection officer is saying. Now, not every business is going to need a data protection officer. There's some a bit of guidance about it from the European regulators. Doesn't really go, I don't think, far enough to actually help most businesses, but essentially the regulation says if you have 250 plus employees, you will need a data protection officer. If you're a public body, you'll need a data protection officer. If you if your core activity is the regular and systematic monitoring of data subjects on a large scale, then you'll need a data protection officer. What's not clear is what core activity means, what regular and systematic monitoring means, and what large scale means. There are some examples in the guidance from the European regulators, but you might need to think carefully about that, about whether your core activity is processing data, and if it is it defined as regular and systematic monitoring, and whether it's on a large scale. Then the problem, as I say, is those three key parts to that requirement, because core activity, systematic and regular monitoring, and large scale aren't defined in the regulation. But you need to look and see whether your business falls within, as much based on the guidance that's available and interpretation of the regulation, has a requirement to have a data protection officer mandated within the business. Now, some regulated areas already have a concept of reporting breaches, but the GDPR implements that for everybody. Under some circumstances, you may need to notify the regulatory body, which is our Information Commissioner in the UK, of a data breach, and you may need to also notify the data subjects so they can do something about it. So if there's a chance that harm could come to the data subjects, then you need to report it to the regulatory body. If there's a high risk to the data subjects, you need to report it to the data subjects as well. So that's a new aspect for most businesses. And then finally, the thing that actually most people are leading with, because everybody seems to be scaremongering at the moment, which is a shame, because it's not the be all and end all of what this is all about. But the regulation introduces a new set levels of fine, and the top level, there's a couple of different levels, but the top level is up to 4% of global turnover, or 20 million euros, and whichever is the largest. But what I will say is that the Information Commissioner has made it clear that, as you can see from what they're doing under Data Protection Act right now, it's all about proportionality, and it's not about the fines. So to give you an example, TalkTalk's data breach of millions of users' data back in 2015 could have been fined for 500,000, because that's the total that a business can be fined under the Data Protection Act, but they were only fined 400,000. An NHS trust who shared data with Google's DeepMind AI program did a lot of work with Google to determine whether they thought it was lawful for them to share the patient records with Google, and concluded that they believed it was, that if patients got a better outcome from their patient care because of the AI program, then that was in everybody's interests. But the Information Commissioner said that they were wrong, but they were able to demonstrate that they'd really taken good care and thought about it, and they didn't get fined, but they did have some changes that they need to put in place, and they're being monitored to make sure those changes are put in place. So there's a couple of examples there of where you know, fines aren't necessarily the be-all and end-all, and this is where the Information Commission is heading on this. So that's 10 of the key changes. That's quite a whistle-stop tour from those things. There's obviously a lot more detail in all of that and how it works. Just very quickly, what does compliance look like? If you're not sure where you sit with data protection, then now's a good time to kick off a GDPR audit, and really you're looking at a 5-step process. Understand what's going on with the GDPR and how you can understand, look at what that might mean to your business, get the senior managers to buy into the fact that you need to do something about it, and get a working group in place of all the key people around your business who have touch points with data, so that they can help you deliver a program of compliance. Second phase is carry out the actual audit, which is understanding what data you have, what systems you use, and what policies you've got in place. And once you've got that, you can then do the analysis, which is looking at what have we got now, how does it need to change going forward with GDPR compliance. So you'll be looking at your data, your policy, and your systems to make sure that they're GDPR compliant. A good area, if you're a marketer, to think about there is in the consent rules. You know, what you've collected so far from data, is that GDPR compliant from a consent point of view? If it's not, you're going to then have to do something about it. So audits, carry out an assessment and come up with a sort of a record of what you've got, data, systems, and policy wise. Analyze, look at how that needs to change going forward with GDPR. And then the delivery phase is all about taking what you know and delivering it in a plan of action before the 25th of May 2018, which is when the regulation becomes law. You also need to look at making sure everybody understands the changes and what they mean, and data protection, so there's employee training involved. And then the final stage is the iterative parts. This is about managing your ongoing compliance, keeping everything up to date. You'll need to deal with data subject access requests. You'll need to deal with making sure your systems are secure, keeping up to date with making sure your employees understand their responsibilities, your policies need reviewing, and so on. So there's a very cyclical compliance program. Data protection isn't a box ticking exercise. Once you've done it, that's it. There's quite a lot to be thinking about, and you need to make sure your compliance is ongoing. So if you're sort of looking at this, and I often say, well, if there's one thing you do, make sure you document, because documents are the things that are going to show that you've paid some attention to the GDPR and what it means for your business. But actually there's essentially 6 things you need to do. We talked about 1, audit your data, systems, and policies. Ideally, if you can, appoint somebody who is going to be your single point of contact. Obviously, if you need a data protection officer by law, that's going to be that person. But if you don't need a data protection officer by law, then appoint somebody who takes responsibility for data protection and keeps the business up to date with their compliance. Document your approach, as I say. Provide internal information and guidance. That might be a mixture of training or stuff on an intranet if you've got that kind of system in place. But the more you empower your employees to understand data protection compliance, the more they can help you maintain your compliance and know when they need to ask questions rather than jump to conclusions about what they're doing with data. And again, as I've already said, maintain your compliance and keep up to date. Now on that point, keeping up to date, the problem we've got at the moment is that we've got a regulation that comes in next year. We've got a data protection bill that I mentioned that's being discussed in Parliament at the moment, which essentially implements the GDPR into UK law post-Brexit. But there's some elements there that might creep in that you need to keep an eye on, and there's also some rules which are implementing some changes with the way that, say, law enforcement and data being processed for national security are managed. There's a new set of privacy rules coming, which are still being discussed, but they want to get them to come in at the same time as the GDPR. And the privacy rules are probably most famous for cookie controls on websites. And the e-privacy regulations may implement some other things. So, for example, before Christmas, a copy was leaked that implied that B2B marketing needed consent, and they removed that. And at the moment, it's all left to member states to decide. But who knows what's going to happen in the further deliberations of the regulation, or indeed how the UK might implement certain aspects of those regulations into UK law. We've also got guidance. We should expect guidance from the ICO well, in fact, they've started on some of them, but they're a bit slow in sort of bringing that out. But There's guidance in draft form on consent, for example, which they're supposed to be publishing in final later this year. And then you've got Article 29 Working Party, which are the European equivalents of the ICO. All across Europe get together and deliver their own guidance on certain things. So there's two sets of guidance to look out for between now and when the rules come into force, and even after the rules are into force. In the UK, we've got to think about Brexit and what that means. If we're no longer in Europe, does that mean we'll be seen as what's called a third country and be outside the EU? So if you're processing data of EU citizens, then there may be some new sort of step change in terms of how you can do that going forward, depending on whether the government convinces Europe that we've got an adequate data protection regime in place. And then you've got enforcement, how one member state may interpret a regulation or an aspect of it might have ramifications across the whole of Europe. So I appreciate that this is a bit of a sort of a bit of a depressing end to the presentation, because there's quite a lot to think about, and it's not just all about the GDPR, unfortunately. But it's unfortunately that those are the things, and these are the kind of reasons why you need to sort of be on top of this and keep up to date. But all's not lost, because I provide services that can help with that. So I talked about digital compliance over at the beginning. It's an online service that you can subscribe to and get access to guidance, toolkits, and information. It covers much wider than GDPR. It looks at privacy and marketing compliance, as well as web and data security. And at the moment, you can try it for 2 weeks for free. So maybe have a look at that. Might be the answer to your compliance needs. And if it's not, or even if it is, I offer consultancy services. So if you need help with your audits to see whether you're GDPR compliant or not, whether you need help in having somebody in place to act as your single point of contact, I'd provide a data protection management service or an outsourced data protection officer, and I can provide consultancy-based services as well as training, and sort of the digital compliance hub fits across all of that. So sorry, that last bit was a bit rushed because I just spotted what the time was. Yeah, so there's help at hand should you need it. So let's move on to questions. I think I've seen some questions come through. I'm just going to have a quick look, and then we'll see what we've got. Okay, so as I said, if you've got some questions, pop them in the questions box, and I'll pick them up at the in this particular section, and we'll try and work through them. Right, so first question. We're a call logging company, and our software brings data from companies' internal directories. Are we okay to assume that legitimate interest covers employers logging their own call information? So I'm not sure I totally understand what that is. If the data enables you to identify a living individual, then you're going to be covered by data protection. If you provide the service where a logging, you're providing a service to enable the controller to do the logging, then they will have responsibilities in terms of how they use, and it would be up to them to decide whether they've got legitimate interest to process that data. You would be the data processor, and you can expect your clients to be asking you to prove your GDPR compliance and how you help them be GDPR compliant. Plus, you've got these new responsibilities as well, and the contractual stuff to worry about. And of course, as you're dealing with, if you're dealing with employees' data, then they are living individuals, regardless of the fact they're working in a business. So therefore, their data is, without any question, is out covered by data protection rules. So I'm not sure whether that really answers your question. I think I probably need to understand a bit more about what your software is doing. If you're providing internal directories of employees for company data point of view, then yes, in terms of using that service for delivering for the company, then I would say they would be looking at using legitimate interest to cover that, but there would be employees within a business. So the rules might be slightly different depending on what you're doing. So sorry, there's a bit of I'm not sure if that actually answered your question, but hopefully it did. Oh, got loads of questions to go through. All right, let's step this up a bit. Right, recruitment company, what's the line with sending through CVs? we take out numbers and emails, so it's only the names and all their experience. Well, if somebody's coming to you to and supplying their CV for the purposes of you finding them a job as a recruitment agency, then that's all part of delivering the service, and it can be expected that you're going to pass that data on to potential employees. There's obviously rules around what you can and can't do with the other aspects of that data, and you may need consent in some way. So, for example, you might need to seek consent if you want to add them to a list of for marketing purposes or something like that. But generally speaking, if you're processing CVs as a recruitment agency, that's your service, and the person is signing up to you processing that data for those purposes. So yeah, so I won't worry about that too much. Jill's asking whether this presentation will be sent to you. Yes, I've been recording it, so you'll get a copy of the presentation and the slides, so a recording of the presentation and a copy of the slides. Okay, so going back to the question about directory logging for employees, just being provided with a bit more information about it being more about whether each employee has to provide consent. So if it's an employee telephone directory for intents and purposes, then that would be considered as part of if there was a requirement to have that kind of system in place, then that would be part of the requirement of being an employee, is that you would be expected to add it to that list. There's obviously strict rules around anybody that outside that might have access to that data, because they are going to be individuals, and therefore that data would be personal. But in a general sense, I think that the employees wouldn't have to provide consent if it was expected that they would be put into the company directory, and it was clear that that was part of being an employee. You would only need to get consent if your clients, as the user of your software, would need to be clear that they've got consent if they wanted to process the data for other purposes. And certainly a good example of that is in the HR world, the generic bottom of your contract. It says, by signing this contract, you agree to allow us to process the data in any way that we see fit, essentially. That's not going to be allowed anymore, because that's not an affirmative consent for other activities that you might process the data for that are maybe outside the scope of what a generic employee would expect with regards to the processing of the data. If I've still not answered your question, feel free to ping me an email. You should have got that in the invite, and obviously in the follow-up with the recording, and I'll try and help a bit further. Okay, we're a few minutes away from when I said I'd end the session, so if you have any more questions, now's the time to get them typed in. If something doesn't come through in the next few seconds, then I'll leave it at that, and I'll just check to see if anybody's busy typing. Doesn't look like it at the moment. Okay, so nothing else has come through, so let's leave it at that. As I said, I've been recording the session, so you can revisit that when I send around a link to where you can see that, and I'll supply a copy of the slides. Hope that was useful, and certainly look out for other webinars I'm running. Some of them are free, some of them are a premium, mainly aimed at Digital Compliance Hub subscribers, but you can get access to those as well. You might just have to pay for them, is what I'm trying to say. Yeah, have a look out for anything that might be of interest, and if there's any particular subject you'd like covered in a webinar, then yeah, ping me an email and let me know, and I'll consider it as a future webinar. Okay, thanks very much for attending. I hope you found it useful. Thanks. Goodbye.